I'm Keith Livesay, attorney in Houston, and I want to explain how the Texas Supreme Court petition for review process works, because there's a common misconception about it. People sometimes think of a petition for review as a second appeal. It's not. It's a request for discretionary review, and the Texas Supreme Court grants a small fraction of the petitions it receives. Here's the structure. In most Texas civil cases, the appeal of right goes to one of the intermediate courts of appeals. There are 14 of them across the state, and they handle the overwhelming majority of civil appeals. When the Court of Appeals issues its opinion, that is usually the end of the road. Either party may file a petition for review in the Texas Supreme Court, but the court decides whether to grant it. What the Texas Supreme Court is looking for is cases that present important questions of Texas law, cases where the courts of appeals have reached conflicting results on the same legal question, or cases involving errors that are significant enough to require correction at the highest level. The court is not in the business of correcting every Court of Appeals decision that went the wrong way. It focuses on questions that matter beyond the immediate parties. This is the key thing to understand when you're evaluating whether to petition. If your case was decided incorrectly under well-settled law, you may have a strong argument that the Court of Appeals got it wrong. That doesn't automatically mean the Texas Supreme Court should take it. The question is whether your case presents the kind of legal issue the court has reason to resolve. A genuinely strong candidate for Texas Supreme Court review usually involves a legal question where reasonable courts could disagree, where there's an existing conflict among the courts of appeals, or where the issue will keep coming up in litigation across the state if it's not resolved. If the answer to those questions is yes, a well-crafted petition that explains clearly why the case matters beyond the parties can get the court's attention. If the answer is no, honest advice is to accept the Court of Appeals result and focus on where to go from there.